Legal Colloquium Brazil-OAS, Good Practices of the Brazilian Law, and Maria da Penha Law and Domestic Violence. We will make available a link in this transmission in the YouTube of the CNJ for the presentation of the panel. As moderator, we invite the counselor Tanya Regina Silva Hexigum, and as panelists from the Ministry of the Woman, Family and Human Rights, Ms. Cristiane Brito, and from Associate Justice from the Santa Catarina State, President of the Collegiate for Coordination of Women in Situation of Domestic Violence and Family Tribunal, Ms. Salete Somariva. We're going to see a short video about domestic violence and the Maria da Penha Law. The video doesn't have audio. We'll play it later. To open, Mrs. Hexigel. Good night to all. Special greetings to my colleagues from the CNJ, my friends, to our Secretary General, Justice and Coordinator of this project, Mr. Marcos Livo. Good night to Dr. Rodrigo, to our panelists, to our Secretary, Dr. Cristiane, and Ms. Salete. I'm very thankful for being able to participate in this event and as a moderator of this panel that deals with a subject that is so dear to me, which is facing domestic violence and the Maria da Penha Law. In the legal aspect, from the Maria da Penha Law, that the judiciary increased their field of action in the issues related to domestic violence and family. Since then, the judiciary power, with the judicial duty of facing violence, domestic violence, which the 267 article of the Federal Constitution has presented, new tools that have the objective of maximizing the objectives of combating this evil. With this history of resolutions, recommendations, and awareness campaigns that were implemented and presented effective results. The various policies in constant development within the CNJ show the commitment of the judiciary power in fulfilling their constitutional duty in guaranteeing the equity of gender and facing domestic violence, aligned to the judicial system with the constitutional precepts that are fundamental to the rule of law and democracy. So with this short introduction, I'm very honored to participate in this panel And of course, I have to say thanks to Minister Fuchs for his support to facing domestic violence and violence of any kind against women. So I'd like to register here my thanks for our colleagues here in the CNJ that defend this cause. So I'll hand over the floor to our first panelist, Dr. Cristiane Brito. She's the National Secretary for Policies for Women from the Ministry of Women, Family and Human Rights. You have 15 minutes. Good night to all. Firstly, I'm Cristiane Brito. This is my signal to the deaf community. I'm white and I have black hair. My eyes are brown and I'm using black glasses. I'm using a white blouse and a navy blue. There's a flag of Brazil behind me and a photograph of the President Bolsonaro. We from the Ministry of Women are provoking a change to guarantee the symbolic act. I hope to inspire all of you to create a more inclusive environment. And here in my self-description, I would like greeting and registering my thanks of the Minister Luis Fux from the CNJ and the organization. Now, Councillor Tanya, Dr. Tanya, I would like to take this opportunity to thank you for your partnership, our partnership with the CNJ in terms of combating violence against women, and I'm referring the Red Sign campaign and Love Doesn't Cause Pain campaign. And we hope to continue to work together in actions that can transform the reality of our women in all of the Brazilian territory. I would also like to greet Justice Salete. I would like to take this opportunity to say our public thanks for the partnership that makes viable the first center for monitoring of protective measures in our country. This work will bring important light. Thank you very much for the conducting of this tribunal and this project, and especially as regard policies to women. And I also have to congratulate those who organized this colloquium. Such different subjects, such as this panel today. And I would like to do something with Dr. Walter that dedicated to produce this work in an admirable manner. Thank you, Dr. Walter, for all your attention for our Council for the Policies of Women. I'd like to thank everyone and allow me to comment very quickly on the historical scenario that this agenda unites us. Violence against women is a challenge for the country, and for many years made natural the violence inside the homes. And we even allowed that these would be justified within a legal norm. Society was so tolerant with this kind of violation that even despite legislative advances, we saw theses like the defense of honor being used. And this became so serious that the shout of a woman beyond our borders, so that everyone could see what was happening with women outside our country as well. and Brazil change in an extraordinary manner. And how proud we are of this awakening. We created one of the best laws in the world, so valuable that it has a mechanism to prohibit, to prevent, to inhibit violence. We're talking about a violence that put concepts, created a structure in the state, and became one of the most well-known laws in our country. We're talking about the Maria da Penha Law. It will be 15 years old now in August. It's our propulsion of all our deeds and orients society with the highlight to the constituting powers. And as the context of that law, we could make specialized courts for domestic violence, police stations, specialized centers, and implement a national policy to face violence in all of our network to promote a humanized treatment of women. We could say that in the last 20 years have been of advance despite high violence in the numbers or rates. We have a network set up, and with that context which I've talked about, what are the barriers that still surround us, and what can this government do to overcome them? These are some of the key questions, and which our policy for women has taken all efforts to fulfill them, and at the same time to give a response to these women through effective actions. And in the list of these barriers, we have the cultural ingredient of machismo to qualify public agents to deal with these incidents. We have the lack of knowledge of the network, under notification, lack of comprehension of the risks that these women take, and financial dependence, and of course fear. And to eliminate these barriers and to create conditions so that women can have a life free of violence, we've worked tirelessly, considering the axis of prevention, aid, combating, guaranteeing rights, production and analysis of data. And in this sense, I would ask your permission to take this opportunity and to talk about some of our good practices. First, prevention. We've carried out campaigns and in the implementation of programs directed to creating awareness in the population, which the Maria da Penha Goes to School program and the Maria da Penha Saves Women. We did with the Federal Districts Tribunal that is being carried out by the Secretariat of National Policies for Women. So this project represents a union of strengths from the executive and judiciary powers and educate to prevent and to inhibit violence against women. So the proposal of Maria da Penha at school is to promote the law among education professionals and to reach children and teenagers in school environments. We, in fact, believe that the scenario of high violence in this country has to go or be dealt with education and education of our children. And with the project Saving Women is a strategy of support, of creating awareness and preventing violence against women through the creation of a network of institutions that are partners, be public and or private. And these partners are committed to go through sensitivity courses and training in terms of dealing with violence against women. When they join, they take on the commitment of doing publicity of educational material, publicity material as regards sexual harassment at work as well as networks that help women. And as regards awareness of our population, we brought up this discussion during the municipal elections as regards political violence against women, never before dealt by the Secretariat before. And in this way, we put the possibility of people reporting this kind of violence, which is our call 180, which is our emergency call for violence against women. So this Secretariat has created the Casas da Mulher Brasileira, houses the Brazilian women, and also police stations for women. And this nucleus, New Yuan, is comfortable within common police stations, and they have the objective of integrated and humanized dealing with these women who are reporting crime. They're trained and create sensibility in dealing with this. In the New Yuan, they can do registers, but they can also receive a psychosocial help during the same procedure. And we're also expanding the Casa da Mulher Brasileira, or the House of the Brazilian Woman, which concentrates in one place a series of specialized services for women who are in situation of violence. And among the services that are made available in the House of the Brazilian Women is psychosocial help, police station for women, judges or people who are specialists in violence against women, economic issues. They can stay for a while. Now we want a compact version of these houses, which we can help these women in cities in the interior of the country. We are putting into the interior these policies, and it's important to highlight that they're in a phase of implementation. More of 20 units of this House of the Brazilian Women, and this represents an effort from the federal government, parliament, judiciary, the states and municipalities. As regards humanized treatment of these women, we've carried out seminaries, contribution or collaboration with police forces. We have published various handbooks, some technical notes and recommendations for adequate work of these services during the pandemic. As regards combating, we suggest suggestions to implement the Maria da Penha law, and we concentrate our partnership with public security agencies. And since the beginning of the pandemic, the Secretariat has been in permanent dialogue with justice agencies, especially those of the states, through their coordinators of domestic violence, to guarantee a humanized and continuous treatment for women in situation of violence. Together with the National Secretariat of Public Security from the Ministry of Justice, we've carried a series of joint actions, like, for example, a technical chamber within the National Council of General Commanders for studies and actions focusing in police actions dealing with violence against women. In this working group, we're also creating guidelines, national guidelines, in helping women in situation of violence with the participation of the technical chamber. We also have training of professionals from the security system as regards violence against women, and a network to help. We've also put new channels so people can report through Human Rights App Brazil in the website of the ministry. It can be done through Telegram or WhatsApp. To guarantee rights, we invested 4.7 million in 2020 in basic food units for these women, considering this context of the pandemic. Besides that, we're carrying out initiatives of professional qualification, entrepreneurship for these women that are in social vulnerability through our project, Qualify Women. I would like to say that this project prioritizes women up to minimum salary and a half that have concluded fundamental education or no education at all. And we invested almost 20 million in developing that policy. We are also working in the national plan in terms of avoiding feminicide. The greatest novelty we have this year is to strengthen the network of protecting women, to reduce the killing of women in this country with structuring and transversal actions. This plan that will be presented soon proposes 55 actions by partners of the federal, state, and municipal partners between 2021 to 2023. These proposals were elaborated within a committee in the Ministry of the Woman, Ministry of Justice and Public Security, Ministry of Citizenship, Education and Health ministries as well. And finally, I couldn't finish without making an appeal that goes to my initial speech on the barriers that we have to overcome so that women can have access to these networks. I refer to the work of creating awareness within the judicial power. This means justices, judges, prosecutors, defenders, collaborators, lawyers, trainees, because data from the Brazilian Public Forum of Security that 55% of the women who suffered violence remained silent and only 23% sought our network. This demonstrates that we need to make a collective effort to present all of the network to women. And more than that, we need to guarantee to these women a humanized treatment, transparent treatment, and without any machismo, institutional machismo. And absolutely nobody should be left behind. But when a woman gives up knocking on the state's door because she wasn't well treated, we have the risk of losing many lives. Let's not forget that when we talk about feminicide, we're talking about the impacts that go beyond the victim.
Our main objective is to bring all of the women victims of violence into this network and to deal with the problem that impacts the entire family. And yes, we are talking about families, because when we talk about feminicides, how many deaths, physical or not, are we talking about? How many people die whenever we kill a mother? So when a father, even if he is the murderer and he commits suicide, and when the children lose their references and the family, they lose a lot as well. So to this end, I would like to wrap up my presentation, inviting all of the organizations present here, take part in the project Save Women, so that we can raise awareness to the largest number of people, and so that we can transform Brazil into a country that truly respects our women. Thank you very much for this opportunity, and I would like to congratulate you on this event, okay? And I would like to congratulate the CNJ, and it's a great pleasure for me to share this presentation with all of you. Thank you so much. We would like to thank you, Dr. Cristiane. Thank you so much for your participation. Thank you so much for all of the words you shared with us, all the information, and together we can save lives. And I hope that we're going to be able to save many lives. Thank you very much. So now we are going to share a video. I believe that our protocol department is going to play a video for us now. Just a second. Okay, Counselor Tanya, I would like to pass the floor to you. Thank you so much. Thank you so much. Now, immediately, we're going to pass the floor to our second speaker of tonight, our second panelist, Associate Justice Salete Somariva. Dr. Salete is the president of the College of the Coordination of Women who are victims of domestic violence at the state courts. So, Dr. Salete, you have 15 minutes to give your presentation. Thank you so much. Initially, I would like to apologize to all of you, with all of the organizers of the event, with Counselor Tanya, with Dr. Cristiane Brito, because I haven't been able to turn on my camera. And so I apologize. And so I tried and tried doing that way in advance, but I haven't been able to turn on my camera. But I believe that you can hear me clearly. Yes, we can hear you clearly, Dr. Saletti. These things happen. Yeah, these are technological issues that have been happening a lot, but we can hear you clearly. Thank you so much. So, first of all, I would like to greet all of the prosecutors of this event, mainly Dr. Walter, okay, Associate Judge of the CNJ, for the brilliant event that is being held now, this legal colloquium. I would like to greet Dr. Tanya, Dr. Cristiane Brito. They are two women that shine, and they are wonderful, and they shine in the sky of Brazil, and they shine in the scenario in which we discuss a lot. They dedicated themselves so much so that Brazilian women, they can have their place in the world. Yes, and so helping them end this submissive position, and so that they can receive everything they deserve that is good. Okay, and now I have been saying that nowadays women are a little more empowered, and this was very difficult for women to achieve this empowerment, this bravery, this boldness to file a complaint and to search for their rights. But through the Maria da Penha law that has already been mentioned, it's a wonderful instrument, and all over the world it's considered one of the three best laws in the world. So, based on this instrument and in all of the work that we have done, and a person that was tired and anxious to solve this, so women have started searching for their rights. And so, we have to remove the obstacles from the front of women, the obstacles that still exist. And we're going to arrive at this place, as Dr. Cristiane mentioned, by raising awareness so that women can truly go up, go further, and achieve everything they have the right to. So, dear Counselor Tanya, I would like to especially thank Justice Fuchs, with all of the respect that we have here at the court in Santa Catarina, the State Court of Santa Catarina, because he has been showing a wonderful profile. He's worried about violence against women, domestic violence, and all of the cases that have to do with the minorities. And so Justice Fuchs has been an example for all of us who have been working with justice, working against domestic violence. And I would like to say that he is an example for all of us so that we can move forward, continue moving forward, even though we're facing difficulties. To Justice Fuchs, our admiration, our respect, and our thanks. And so we have lack of light in some places, and the violence against women. And some women even became slaves. They were in a submissive situation, they were facing male chauvinism. There was a culture of male chauvinism. And in Brazil, this has been happening for many, many years, for a long time. And it's like the men are the owners of women. It's like women is their possession. And so this is part of our culture. And for a long time, male chauvinism became stronger and stronger. And a few decades ago, Still, women were totally dependent on their partners and husbands, and they were like possessions of their husbands or their partners. F- Fortunately, time went by, the movements became stronger, and then in the 1970s, there was an explosion. And so, with the feminist manifestations, and so in the 1970s, they started recognizing the value that they have. The women recognized that, and that they had the same value as their husbands or partners, okay? That were male partners. And so women started attending universities and colleges. They started finding jobs at companies or at other organizations, and they were able to give the first steps. And so in 1985, we had the first Council for Women. And then we had some pieces of legislation that were enacted. The Civil Code was reformed in 2002, and other tools that it was a boom, and this boom ended up resulting in the Maria da Penha law. This tool that was enacted in 2016, it opened up many doors and possibilities, and it made it possible for the dreams of many people to make women it transform women into beings at the same level as the male being. So the Maria da Penha law is a more preventive law, but it brought with it so much light, so much inspiration. It took a while for it to arrive and say, I'm here, I am an instrument. Look me up, I'm here to protect all the women. But this moment of the Maria da Penha law only became a concrete fact when the CNJ created the departments, the special departments for women in all of the courts all over Brazil. And so, if we think about it deeply, this resolution from the CNJ was a milestone in history. So it created state departments to offer care and support to victims of domestic violence. And so the CNJ expanded everyone's power. And these departments, the state departments, opened up the path because we almost didn't talk about defending women or the defense of women. So the problems regarding women, they were decided in special courts. And so when this resolution was published jointly with the Maria da Penha law, it shed light in the situation. And then the huge networks of care and defense started being formed, and Brazil woke up. And I say that Brazil woke up because at that time we had a homicide of women. Everybody on the news talked about it. Oh, the husband killed his wife. Oh, because she was wearing a sexy outfit or something like that. And so the women, they were considered something inferior to men. And with the Maria da Penha law, this resolution by the CNJ, so the perspective changed radically. And so the Maria da Penha law reduced many cases of domestic violence. And I answer, no, for me it's not. The math is not so important for me of how many cases it diminished or reduced. For me it's important to say that the Maria da Penha law opened up paths, and women started becoming more courageous to file complaints, and our society woke up a little bit from that situation that was abnormal, how things happened. So men are killing our women, and the most important aspect of this is that men started waking up as well, because all of the problems that took place, they were a result of something that the woman did, something that the woman made. And so that they had to do something. They had to do something and we decided we had to do something to defend our women. So after many, many centuries living in this total darkness, we started facing and living through another reality, because the networks got together, the population got together. Everybody's worried about solving this problem that is so delicate and so sensitive, because I believe Dr. Christiani mentioned that the problem related to a feminicide, it's not only the woman that dies, sometimes the entire family dies, and they also kill the family of the man that committed the feminicide. And so people that didn't even have criminal history, and so some people take their space in the situation, even if they are of the higher classes, middle classes, and then there is a problem. And then what we have is a terrible cycle. And so the children of the feminicide are going to suffer. What is going to happen with these children and teenagers in the future? Are they being welcomed by their families, received by their families? Well, I would like to speak briefly because I know my time is limited, but the departments, the state departments, are very important. And after these efforts working together, and so in 2018, when these departments were created, when the Foravídeo ended, the Domestic Violence Forum, and so there was the creation of the COSEVID. Okay, so you have all of the states in Brazil and the federal district. And so Associate Justice Erotildes from the state of Mato Grosso was the president of this COSEVID, and for the second time we had to listen to the state departments, because everything in Mato Grosso, in Rio Grande do Sul, São Paulo, everything was separated, and now we are speaking the same language. We exchange messages and information on a daily basis. We carry out meetings. We are all working together in an integrated way, in a single way, and the results are way bigger. And so I just wanted to mention some of the projects. I'm going to speak briefly about them because we have so many. And so I'm going to mention some of the projects that were launched by the Brazilian Association of Associate Justices, by our president, and by the CNJ, by our dear counselors, Dr. Tanya, Counselor Cristiane Ziova, and Counselor Flavia. And then COSEVID, they became together. And so after this project, we had the Red Light Project. And so from the experience that I'm having now, it is the best project in the world, in the world. There is no project that can compare to this red light project or red traffic light project. And so the reduction of the imprisonment of women in their homes now during the pandemic, throughout these 12, 13, or 14 months, they were totally isolated, socially isolated. They were victims of their harassers, their partners, their husbands, okay, and they had no way out. And so Counselor Tanya, we decided to do this, not, and so we talked to the military police department, to the civil police department, all of the state departments, okay, and they're doing wonderful work, and so we had meaningful work. And so I have just heard that a lady who was at risk, and so she showed it. She showed something on her hand, written on her hand, to a police officer, to a military police officer. And so that police officer helped that lady. And so the project expanded, and she was showing the hand with something. Oh, it was not something written, it was a red cross. A red cross. And so the red sign meant that she was in danger. And I believe that this is the biggest project in the world. And all of those that participated, okay, mainly the Association of Associate Justices and the CNJ, we need to pay homage to them because they have written their names and inserted their names into the history books. And so I would also like to mention work that is being done. COSEVID is doing COSEVID, which is important work. It is work about the groups. COSEVID created a group so that they could work, the reflection groups, to work on these matters. And so we had the participation of many experts on this matter, on this topic, two psychologists, and I don't know if he's a psychiatrist. I'm sorry, I can't remember properly. But they have PhDs, master's courses, and they are true experts in Santa Catarina and also in the state of Paraná. And together with them, and so the legal secretariat of COSEVID, the president there is very competent. She has many capacity building courses in her resume. She has a degree in law. She has a master in law, and so there were other participations, and she is also highly dedicated to this issue.
And this work is so interesting because COSEVID and all coordinations, this was raised in each coordination in their state, the issue of these groups for reflection. We needed to know a photograph, an x-ray of how in Brazil we were in terms of these groups for men. These also, they do some extra work abroad, and they stated that there doesn't exist in the world a work like we did with COSEVID. And we saw that in Brazil there are 312 of these reflection groups for men. And this work done in September, it will be sent to the CNJ, and with our requests we need to know how it will be implanted, what will be the directives of this group, because we did a survey. Now we have to implement these groups in terms to operate the Maria da Penha law. I just like to point out one more project and I'll stop. I know my time is ending. It's a project of Dr. Jaqueline from the Mato Grosso state, that in this time of pandemic, Dr. Jaqueline is very creative, very active, and she created a system of protective measures online. Even before the registry of the crime or the problem, the woman in a situation of risk, they can do a protection order online. I thought it was a very fantastic work. It was a pilot project, and it's still being in draft form, let's say. And in Santa Catarina, we have also a format to change these reflection groups, to transform them, to train all of education professionals to deal with children in the situation of violence, and others more, but I'll stop here. I would just like to say that at this moment, to ratify what Dr. Cristiane mentioned of our responsibility in creating awareness. It's not enough to do projects, create houses, programs, if there isn't an awareness by those people. People had to be directed to that issue. They have to direct beyond their eyes and to know when they're dealing with a woman in a terrible situation and she needs support and some kind in an environmental to expose her problem, and she is treated in an austere or indifferent manner, and like we mentioned, women fall back and due to one badly spoken word, one sentence that is more aggressive. If they say, "Oh, it's just a fight in your house, go back to your husband," and the woman might never go back and seek the judiciary that today seeks so much to help her in those issues. So here is my requests in the name of the COSEVID and other coordinations, that we have this responsibility of finding mechanisms to go beyond our work or projects, to create sensibility in terms of everyone that is working. Only in that way can we change how things are and contribute to a real evolution of society where we can live in a climate of respect. Thank you very much. We thank you, Justice Salete. Today it's a reason to commemorate, to hear Cristiane, Salete, and to know that we are contributing. I'd like to take the opportunity and talk about our campaign. Our Red Sign campaign, is 1 year old now. We're having our birthday, let's say, and I'd like to register here that the Red Sign has become a law in some states, 7 states. And here in the south of Brazil, Rio Grande do Sul, I will comment, inform. We will launch the Red Sign in the first municipality on the 18th of June, and it will be in Gramado. Gramado was chosen by us to be the first city of Rio Grande do Sul to join the campaign, and with a cooperation work. With our story, its representation, what Gramado represents at the national and international level. So Gramado will be the first city of the south of Rio Grande do Sul to have this campaign. Also, I'd like to register partner and colleague Justice Maria Teresa, that is in our panel today. And as soon as I saw her, she's a colleague, concerned, she's a partner with these issues of violence in terms of gender and women's issues. Thank you very much. And I would put a closing speech in the same way I started. I want to also end thanking Dr. Marcos. He's been a great partner to all the projects of the CNJ and in the Red Sign campaign as regards domestic violence as well. Marcos Livio has been a great partner. That's the expression I could use. When he proposed in our Congress, said, "Tanya, let's include this partnership in this important event, and as regards violence against women." That's how we do policy. That's how we are contributing to a fairer country without deaths. When Dr. Cristiane and Justice Salete said, what do we all want? We want something that doesn't end only the life of that woman, but of a whole family, and we are all responsible for those orphans, for that father that committed that crime, and all of society. And it seems that we are advancing so that society is aware. And I would like to talk once more of the prize we set up in the CNJ from Judge Viviane Amaral. People can register and participate to bring the good practices so that we reproduce them all over the country in order to combat domestic violence. I'm very satisfied with our panel. Thank you very much for our panelists. Thank you. You can count with me, with the CNJ, Justice Salete as well, and I'm certain in the name of Renata, Christian, Flavia, very caring words, and Salete. And this doesn't stop us, despite the pandemic, to get to know each other at a distance and have this brotherhood with Secretary Cristiani, Justice Salete, all these men and women who work against violence against women and to end this world, and these judges that work, especially those that work in those courts dealing with this problem with violence against women. Thank you to all, and I'd like to declare close this panel tonight. Thank you. I'd like Minister Justice Maria Cristina and Mr. Walter Schrenk to present the good juridical practice in Brazilian agribusiness. We'd like to invite as moderator Secretary of Special Programs, Research and Strategic Management, Mr. Marcos Livio Gomes from the CNJ, Luiz Antônio, Dr. Paulo Gustavo Medeiros Carvalho, from the CNA, the Confederation of Agriculture, Mr. Dr. Rodrigo Kaufmann, and Mr. Luiz Antônio Naba Garcia. We want to see a video about best practices in Brazil.
Negócio que a cada ano bate recordes de produção, amplia mercados internacionais e representa mais de 25% do produto interno bruto brasileiro, o agronegócio é um setor fundamental para a economia nacional. O cumprimento das bases legais que norteiam o desenvolvimento dessas atividades, o que inclui obedecer normas da regularização fundiária, da preservação ambiental, assim como o uso de defensivos agrícolas, traz a segurança jurídica que é fundamental para garantir concorrência leal entre produtores e o bom desempenho do agronegócio. O agronegócio possibilita que a propriedade atenda à sua função social e que se promova o desenvolvimento nacional sustentável. E o Poder Judiciário brasileiro tem a relevante missão de proporcionar estabilidade e previsibilidade nas relações jurídicas destes agentes econômicos.
To conduct, I hand over to the moderator, Marcos Livio Gomes. Good night to all. I'd like to greet the National, Miss Maria Teresa Moura. I'd like to greet my colleagues in the panel, Dr. Paulo Gustavo Medeiros Carvalho, and I'm a suspect, and Dr. Rodrigo Kaufman and Dr. Rodrigo Kaufman, a juridical aid of the CNA, and I couldn't start without greeting my dear friend. I'm a great fan, which is of Counselor Tanya. I know CNJ will give great steps as regards violence against women. I think this is a historical depth of Brazilian society, and we are dealing with this depth with judicial policies that are solid, based on evidence, strategic. You can count with the strategic management of CNJ to create indicators, objectives that can deal with this complex journey, and certainly you are very well and capable. I'd also like to greet dear friend, and I'd like to hand over to Dr. Paulo Gustavo, but are doing a consideration. I will give myself the right of setting a seed of discord in this panel. Let's see if we can do a dialectics at the end. One of the great challenges in terms of land issues is to obtain the information from CGEFs as an API, informations that could be downloaded automatically, but all units in the judiciary of Brazil. And certainly this would be an advance, technological advance, in terms of carrying out those activities in a way more effective manner. So I like to put it to debate. And as regards Dr. Rodrigo, from the Observatory of the Environment, created by Minister Fuchs in this term, and is working very much as regards normative acts, research, actions that can improve the efficiency of the justice system, the judiciary power, as regards the environment. We feel that we need a robust project of the CNA as regards projects that the activity, agricultural activity, which is the great source of income for Brazilian commodities, but projects that align this activity with the preservation of the environment. And we want concrete projects that give effectivity to the economic activity, but that do preserve the environment. So I would like to throw the two seeds here, and I hope we can do good debates. I'd like to hand over the floor to Paulo Gustavo for 15 minutes. I'd like to greet our president, Mr. Marcos Livio Gomes, which is a great friend, and in this aspect I'm very suspect in making too much praise. And I also like to Justice Maria Cristina, Consul Teresa, and my colleague and also friend, Dr. Rodrigo Kaufman, which is a specialist in the theme from the CNA, Dr. Walter Schwenking. I thank very much the invitation by the CNJ. And without further ado, I would like to deal a little bit with the theme. We verified that this theme is of extreme relevance. The country ends up being a big agricultural border or frontier, or could be called and the silo of the world. Of course, we have some problems, and some of them I'll talk about them. The first issue is that is of interest, that there sometimes is a false dilemma between the agricultural and the environmental. Putting here a little bit of controversy as well in the discussion, because there is a possibility, yes, of having agricultural activity like we have in Brazil, and I'd like to highlight that the area destined to agriculture in the Brazil is only 7% of the national territory, and it's half that of what is put for indigenous lands. Not that they should be compared, but it's only 7% of the Brazilian area which is destined to agriculture. And there is a need of great juridical safety. And I talk about regulating land ownage. I also due to environmental issues. That's why I say it's a false dilemma. Brazilian legislation in some biomes, like in the Amazon, end up determining that 80% of an area should be kept as a natural reserve, which is perfect, aligned with the idea of preserving the environment. That we should say this was passed by the National Congress. But now we verified that most of the penalties
And most of the environmental crimes that are committed, the fires, the criminal fires, they are identified in areas that many times they belong to the federal government or to the states, over which there was no legalization or. And so the surveillance nowadays is done via satellites, not face to face or in loco or there at the site. And so if there is the identification of the area, and so there is an objective liability or responsibility person. Translation apologizes, his video has frozen. And they are even going to allow, I can see Dr. Walter Schrank that wrote well about the principle of reliability, of legitimate trust. Why? Because it brings with it parameters, time parameters, the impossibility of increasing the area or the land. Why? So that we can have balances and we can establish greater greater legal security. And so when it comes to this topic of indigenous lands, we have a parameter that was not a legal parameter in the strict meaning of the word. There was no law setting forth what were the conditions or what were the parameters, and so there was only a decree 1775 that discussed the topic, and besides the statute, of course. And so the Supreme Court was able in 2008, if I'm not mistaken, they established a few parameters. The same way, we have something similar when it comes to the maroon communities. And so the path is a little more open. We don't know, for instance, the time frame, the time parameters, if there is, for example, if they have the deeds to their homes, if it is a collective deed to their land. And so, if we can give a deed to a person who already lived in these maroon communities, and so if they were removing those people from that land, if there would be the need so that we can pay damages or an indemnity for the people who are there, because that is a collective village, a collective space, at least as we have in the maroon communities in Brazil. And so there is the need to establish this parameter. On the other hand, whenever we talk about the agrarian reform here in Brazil, we verify as well as something becoming concrete, something that the Constitution established, the social function. Whenever there is a huge lot of land, if they are not serving us their social purpose, maybe we are going to remove those people from that land. And regarding this theme, we have the need to have, for instance, greater effort on our side so that we can give them these deeds, these land deeds. Because how do we have a land reform? The deeds are going to give them legal security, and those who were settled on that land as a small producer or small farmer, and so they're going to receive the deed, and then they are going to receive a temporary deed, and after that, after some conditions are met, they're going to receive the permanent deed. And so for quite some time there was a huge concern when it came to removing those people from that land, yes, from these lands. And we are now living through a second moment, and the main idea is to guarantee the deeds for those that are there. Living and settled on that land, those that are beneficiaries of the land reforms, they are small farmers, and this is going to become a best practice. Why? Because this can be considered somebody that is never going to have conditions and more than a small farmer, and they're going to be able to contribute with the family farming that we have in Brazil. And the Ministry of Agriculture now has a department especially made for the family farming and for cooperatives. We also have the land legislation and regulation, and when it comes to this topic, it's important for us to discuss the fact that many times we should simplify the procedures, and then this legalization becomes better, more effective. And why? Because basically the legislation, when it sets forth the land legalization, there is a surveillance, there is a monitoring, and INCRA, that is the agency that should carry out this surveillance. They don't have enough personnel, and the distances are huge between the head department of INCRA, the headquarters of INCRA, and the lands. And there are other means, other ways with the same legal security that can make the procedures faster. We can use an app, for instance. So every time we analyze, and there is a census. We had a census in 2010 and also in 2000, 2001, and there is a possibility of verifying if that family, that person who is demanding that piece of land, was already settled on that land. And on the other hand, we also have the cross-referencing of databases, and there is the possibility of verifying if that person is carrying out that activity, an agricultural activity, if all of the requisites are being met. The legal requisites, 11952, law 11952, and if it's being correctly met and followed. And by doing this, we're going to be able to legalize the land in a more effective way. In a more effective way, why? Because the procedure is going to become faster and safer and more secure. And so, without changing any kind of legal device, well, better saying, any kind of legal requisite to legalize that piece of land. And we try to do that within 910 provisional measure. And now there are two bills of law at the Senate and at the House of Representatives, 2699 and 210 at the Senate. And so all of the area, and the Constitution sets forth the legalization of up to 500 hectares. Another point that is an excellent practice that we can have regarding the land issues is having a uniformity in the system. And INCRA, this agency, and we're getting in touch with the CNJ as well, so that we can assist them, advise INCRA in this idea of creating a system, a single system, and making the notary publics, they can access the CGF, not the access that we have now. Because now the access that the notary publics have is extremely limited. But we want them to have a wider, a broader access. And the deeds or the registration of the land can also be informed on the system. And in order for us to do that, the databases, they are leaving INCRA and migrating to SERPRO. SERPRO, we have this project now. And on top of Professor Marcos Livio's question, my dear friend Marcos Livio, I would like to emphasize that this is extremely important. Extremely important. This perspective of uniting the CNJ and the notary publics, the notary public offices to the executive branch, SEAF, INCRA. Why? Because together they can work and also to bring about legal security, be it for the notary public that is going to establish and they're going to have to register to create a deed for that piece of land, or be it for INCRA. And many times we have noticed the lack of dialogues, the lack of conversations between the notary public offices, and the work that INCRA does generates a few problems. and everything is in a single system. And if everything were in a single system, this would become simpler. There is no overlapping, and so we have INCRA working, the notary public offices working. So basically, I don't want to speak for much longer. I believe that I have reached my time limit, and I'm at your disposal. Thank you so much for this invitation. And I would like to pass the floor to the president and the moderator, Marcos Livio. Thank you, Paulo. And I would like to pass the floor without much further ado to Dr. Rodrigo Kaufman. Well, good evening, ladies and gentlemen. First of all, I would like to congratulate the CNJ in the name of Justice Fuchs that was creating jointly with the OAS this important legal colloquium. And I would like to highlight the importance of discussing also the agriculture and livestock production in Brazil, and they are highlighted in the Brazilian law nowadays. I would also like to congratulate Dr. Marcos Livius and Dr. Walter Schrenkner for promoting this event, and all of the organization, the managing, the intellectual part. And this panel is very important. It's a great pleasure to be part of this legal colloquium. I would also like to greet my dear friend, Dr. Paulo Gustavio. He's an expert not only when it comes to law, but also in the practical aspects of all land issues and agriculture in Brazil. And he's essential in the creation and maintenance of the public policies in the agricultural sector. And I would also like to greet all of you who are taking part in this event. I can see Professor Ingo Salles, he's here. I don't know if Associate Justice Salete is here, but I would like to also greet Justice Maria Teresa, well, all of you. Hello and good evening. So I'm the only panelist, I believe, that is going to speak on behalf of the private sector. So my presentation is going to be a little different. So since I don't have the authority to talk about public policies directly, even though the CNA, the National Confederation of Agriculture, and so we participate, and we make a point of participating as a partner, as an aid, as an assistant in the creation of public policies. And so also we work with the legislative branch and also with the judiciary branch. And maybe this piece of information is well known by all of you, and maybe those that are not within the agricultural sector don't know some data regarding the Brazilian agriculture. And we lost a little bit of the sector, of the boom of this sector. We're talking about a sector that represents now about 26.6% of our GDP. It's continuously growing, and this percentage used to be much lower. 48.8% of the commodities exported by Brazil come from agriculture. And in 2021, we broke a record, the VBP, which is the gross value of the exports in Brazil and commodities. We are leaders in the production of sugarcane, soybeans, orange juice, and many other products. We are also the leader when it comes to the exporting of beef, poultry, paper, celluloses, maize. So we are a protagonist in the world market, not only when it comes to commodities, but other products. And so now today, in our productive chain, according to the census of 2017, we have over 5 million farmers. And so most of this set is formed by small farmers and family farmers. And so all of the public policies and the concerns that entities such as the CNA has, the National Confederation of Agriculture, and we aim to protect the farmers And so we have the family farmers and we try to protect them. And when it comes, one of the aspects of the questions made by Marcos Livio, I'm going to repeat this motto that Dr. Paulo Gustavo said: there is a marriage, there is a synergy, a necessary synergy or marriage between agricultural production, livestock production, production of food, and the environment. And so nowadays we see in Brazil that according to data from Embrapa, 66.4% of our territory is meant for the protection of the environment in all of these forms and shapes, via the creation of reserves, natural reserves, preservation reserves, or the native areas or areas that cannot be produced, or indigenous areas, or in less half of this percentage, they are environmental protection areas that are within the rural lands that belong to private farmers. And so only this piece of data shows that the farmers in Brazil, they are the largest promoters of environmental protection in Brazil by law. Okay, but not only by law, they have to preserve this from our forest code, but it's a practical issue because the production of food in Brazil and the livestock and agricultural production in Brazil depends on a well-balanced environment, and so the environment must be sustainable.
Sometimes when our legal defenses, we say we say this, but it seems to be ethereal. But in practice, that's what it's about. The farmers are the ones most interested in keeping the environments. And in answering to Dr. Marcos, we have a lot of programs that orient this kind of development of activities. I'm going to mention some, but this first information is important, that there is a necessary marriage between producing food and environment. As regards the strength of agriculture in Brazil, there is an important concern about the extreme responsibility of all agents in the agriculture, legal or as well, like myself, everything that is produced in agriculture, including in the juridical, the thesis, the solutions, normative solutions, the instruments, the interactions with public power, with the contacts with data and intelligence, with parliamentarians or judges. All of this that the agricultural sector does to defend its industry, these are connected with this idea of all agents of responsibility and in terms of agriculture. The second point, in the last years, agriculture has been suffering a challenge. This challenge to overcome of a lot of disinformation as regards Brazilian farmers and a certain internal opposition. All of the representativity of agro, all the intelligence created within, concluded a few years ago that the best answer to this, to face this challenge, is to promote, and I use the expression of the good practice, economics, entrepreneurial, environmental, and political, juridical. If you understand best practices as correct, ethical practice, republican, transparent, that's exactly that is our main appeal of the best practices in agriculture. We're not is not a liberality of the agents. No, we're ahead facing a need. The importance of agriculture is that we should take on responsibility, and in terms of best practices in law, even though we're not public, we are doing some kind of public work. We're talking the name of the Brazilian population of our country. So there's a synergy between private actions that has public interests, and this partnership happens, of course, with the public powers. So what is the best practices as regards, for example, the CNA? I think there's the adoption of three big principles. The first is we only think agriculture or the agro. If you think together, the growth of the country and the improvement of Brazilians' well-being. What does that mean? Is that from the point of view of agriculture and its agents, there is no interest from agriculture that is opposed to the national interests of the understanding of what is the growth and the improvement of the conditions of the population, including access to food, which is a constitutional right that is guaranteed. It's not that people just looking at their own activities, but people are thinking about the country with a view from the agriculture. The second is this problem, which Dr. Paulo put. In fact, there is a marriage between agriculture and environment. That our mantra, in a certain way, is the expression sustainable development. There doesn't exist development of agriculture without environmental concerns. This comes from decades already. Of course, we're improving these practices. There are other demands from environmental origin that have to match these new production needs and the development of the production. Of course, but there is a necessary marriage, and everything in agriculture has an eye in terms of environment. CNA participates in various campaigns together with the farmers. As regards green finance, for example, we had an approval, the FIAGRO, which is a fund to attract from abroad as well. And one of the ideas is the idea is to use the green bonds. It's another way to improve and give incentive to agricultural production with more environmental concern. This is the reality of the farmers at the point. It's impossible to think about agriculture if the idea that is associated that they're destroying the forest or pollution doesn't make sense. Economic sense, social sense of those that work in agriculture. And finally, the idea of responsibility that we highlight in terms of this position of agriculture that is divided in various areas. We have the social responsibility, so connected to CNA. We have the SINA service that affects 2 million farmers a year, and a lot of these programs have to do with of the development of agriculture with social and environmental responsibility to take the farmer from a situation of misery and with productivity take him out of that situation, but with environmental concerns. Some things that are intuitive for these farmers, they're improved by SENA and CNA. So these three values and objectives, I think, shows the best practices in the juridical sense. First, no agriculture can't be thought without country. Agriculture cannot be thought without environment, and agriculture cannot be thought about without political, social justice issues. So there is a range of responsibilities that we take on as ours due to the position that agriculture has in the Brazilian economy. As about the more concrete objectives, we have some important flags or that represent the seeking of best juridical practices but help to develop the country. We want legal security, juridical security for farmers, and the right to property is fundamental for the development of agricultural activities. Transparency, publicity, it's not a closed sector wants to hide their practices. Quite the opposite. We give a lot of publicity and transparency to our practices, and we want to discuss these in the public arena with partners that would, in principle, be considered our opponents. No, but they are not. We have discussion with various sectors in Brazilian society, also professionalization of farmers. The more he will understand and respect the environment, and adoption of technology, not only mechanized technology, but the one produced by their own inputs. And I think the classical example is agricultural inputs or pesticides. So this puts in practices which I will mention here, but that help what we want to say when we talk about sustainable development and agriculture hands together with environment. So as regards the legislative power, we work firmly and as a partner and of the legislative process, which was the Forest Code. The Forest Code is the most important after the Constitution. It is fundamental. It's the axis, the legislative choice, autonomous by the legislative power, that designs this marriage between production and environment. And we think, when we call it a great paradigm, and we approved the agro law that gave more guarantees to the agricultural sector and that they be open to investment in agriculture for the capital markets and foreign markets. To take a little bit about the pressure of public banks that were usually involved. And we've also had the approval of the FIAGRO law, and recently this year also with participation of the 4119 that talks about paying of environmental services, where you democratize and you share with farmers the responsibility of protecting the environment. We are now in a discussion, fundamental, also highlighted by Dr. Paulo Gustavo, of recognizing a wider land issue law. There's a law bill, two law bills, because to guarantee the legal security of the ownage of that land means more responsibility will be guaranteed. When we have a land ownership diagnostic, we can see who is lacking in defending the environment, and we can say, look, maybe this is not a farmer, maybe it's someone who's irregular, maybe it's even a criminal. So it's important for us to approve this law, because it will separate the wheat from the chaff, and because now it's very mixed and it's bad for the image of Brazilian agriculture. And we also have a law about environmental licensing, which is fundamental. This is the way we found it, in order with the discussions in Congress, for us to have concrete policies that are individualized in terms of protecting the environment, and joint when necessary or possible with enterprises or productive activities of agriculture or other sectors. The approval of this legislation is necessary in terms of professionalization, legal security, the issue of technology, and as regards the environment. I'll abuse a little bit. There's a lot of disinformation on the legislation, especially if there's a certain, if there's something, these law bills that is not very well. So it's fundamental for agriculture, for environmental protection. As regards the executive power, we deal directly in terms of the responsibility of these agricultural sectors. So we can say that the self-control program in increasing the use of biological products in order to defend the crops. And there's the issue of productivity that is fundamental. There is a dialogue with the Ministry of Agriculture of the Safra plan every year, which makes viable agriculture, especially from small farmers or producers. The action to increase the connectivity of the rural areas. 25% of our rural sector has coverage from mobile cell phones. We can increase to 100 billion if we increase this connectivity in terms of labor laws and the regulation norm 31. This was negotiated, which gives greater protection to workers and training of those that work in agriculture, infrastructure, a permanent dialogue with responsibility in terms of concessions of highways, waterways, improvement of airports, and also improvement of... Dr. Rodrigo, sorry to intervene. Due to the irrelevance of the theme, you were given 20 minutes. But unfortunately, we have to obey the timetable here because the next panel is already ready. So, 1 minute to conclude, thanks. So the conclusion that I would bring, in fact, we still have a great challenge as regards the judiciary and to overcome the idea that there is an antagonism between agriculture and environment. They complement each other, they're fundamental. And just to answer the provocation of Your Excellency, in fact, CNA has a lot of programs as regards preserving the environment. It would be good to go deeper in these topics, but I'd like to leave a provocation. CNA tried to be part of this important initiative of the Observatory of the Environment. So I'd like to ask our colleagues of the CNJ that we can be part of that panel. I think we have a lot to contribute because the only participation of agriculture is more in the agricultural industry and not farmers like the CNA has, to a wider representation. I apologize for going over time, and once more, if you need, and congratulations for this colloquium. Thank you very much. We'll take it to Minister Fuchs tomorrow as regards the progress of the country. Ladies and gentlemen, thank you for your participation. Ladies and gentlemen, we thank you for the presentation. Let's present the concretization of human rights by the judiciary power and judicialization of health. As a moderator, counselor of CNJ, Mrs. Candelice Lovacat Galvão Jobim, and the justice from the Rio Grande do Sul state, Ingo Sarlich, and professor of law from the FGV, Mr. Daniel Wang. We'll see a short video here, Judicialization of Health.
A saúde é direito de todos e dever do Estado. O artigo 196 da Constituição Federal foi claro ao determinar que este é um direito social fundamental e universal dos brasileiros. Ao instituir o Sistema Único de Saúde, o SUS, o texto constitucional assegurou o acesso gratuito, universal, integral, descentralizado e igualitário a todos, da vacinação ao fornecimento de medicamentos de alto custo. Casos de não fornecimento pelo poder público de tratamento médico, UTI e medicamentos deram início a um fenômeno que cresce de forma exponencial no país: a judicialização da saúde. Atualmente, mais de 2 milhões de processos relacionados ao tema tramitam na justiça brasileira. O cenário atinge diretamente a atuação dos juízes e, em virtude disso, o Conselho Nacional de Justiça se debruça sobre o tema com o objetivo de ajudar magistrados e tribunais a equacionarem uma complexa conta que inclui a garantia de direitos dos pacientes sem desequilibrar o sistema de saúde. E, neste sentido, ações já podem ser vistas, como, por exemplo, a criação dos primeiros núcleos de Justiça 4.0 pelos tribunais regionais federais da 2ª e 4ª regiões, dedicados a matérias relacionadas à saúde.
To conduct this panel, I would like to pass the floor to Councillor Candice Lavocá Galvão Jobim. Thank you so much. Good evening to all. First of all, I would like to greet our two panelists today and speakers, Dr. Ingo Sarlet, Dr. Daniel Wang. Okay, it's a great honor and a pleasure to be here as the chairwoman of this panel during the presentation of these two wonderful experts on human rights. Okay, and so since we are with our time very limited, I would like to let the speakers know that they have 15 minutes each for their presentations, and I'm not gonna take a long time so that we're not gonna waste any time. And so we would love to listen to you. So everybody is expecting your presentations a lot. So first of all, I would like to pass the floor to Dr. Ingo Sarlet. He is a professor and a retired associate justice from the State Court of Rio Grande do Sul. He was a professor at Harvard Law School. He has a PhD in human rights from the University of Sevilla and also from the University of Lisbon. And he has also courses from the University of South Africa and also from the Granada University in Spain. Okay, he started his career in Rio Grande do Sul in 1991, and he was promoted due to his time as a judge in 2015, and he retired in March of 2019. And so, with a lot of joy, I'm gonna like to pass the floor to Dr. Ingo Sarlet. First of all, I would like to thank all of you and the organizers of this event, mainly the staff from the CNJ. It's a great honor for me to take part in this event. And also I would like to greet Justice Fuchs. And also I would like to greet all of you. On behalf also, I would also like to thank Councillor Candice Lavocá Galvão Jobim, and I would like to greet all of the other speakers and also my dear friend, here on the panel, Professor Daniel Wang. He is an expert on this topic, and he's also a critic when and he has a lot to offer when it comes to this area, and he also knows this topic well in English, so it's a great honor to be a member of the panel with Professor Daniel Wang. So I have just 15 minutes. My time is very limited, and so I would like the moderator to please interrupt me if I go over my time. Okay, please do that, don't worry. And so I would like to discuss a few aspects that I thought were going to be very interesting to start this panel, and then Professor Daniel is going to continue this and maybe correct my presentation. One is a general perspective, okay, regarding the judicialization of our health. And so the political, the social, the media agenda has already been discussing this, and we are now discussing a few things, a few phases that we can highlight. The first phase, that in the mid 1990s up until the year 2000, there was an incipient phase, and we started discussing this with a judge, access to medication, and some packages for the medication to fight against HIV, hepatitis. Up until 2009, 2010, we had a huge expansion of the judicialization, and based on certain rulings, sentences, okay, and other actions of the government, the public power, and so there were many arguments, and there was a few specificities. At least in my state it was like this. And so if you file a lawsuit, you're gonna get it. If you don't file a lawsuit, you're not gonna get it, okay, because sometimes there's no intervention. And after 2010, and so okay, it's my personal classification, okay, after 2010 we started a trajectory so that we could start rebuilding some criteria, and also the construction of a few criteria on the part of the Supreme Court and their sentences. And also the CNJ started working hard on this topic, the first resolutions, the first recommendations, and a few actions. And parallel to that, the STJ also had some rulings and sentences, and we saw some relevant actions and work when it came to this. And there was a fight against the doctrines, and so there was a phenomenon, be it doctrine, be it the actions, and then we started growing this. There was a laboratory that was very important when it comes to these issues. And so in quantitative terms, we know that the data, they are staggering. So we have reports of 2017 and 2016. We already had 1,347,000 lawsuits involving the right to health, the right to health care, and 25% they were dedicated to the access to medication. And there was a 1,300% growth between 2010 and 2017, and in the proportion because of post practices of reconstruction of the model. And so between 2010 and 2016, the federal government used about 4.5 billion reais only to meet the demands, the lawsuits and the legal demands. And towards the end of 2017, it was about 7 billion reais only to meet the demands of the lawsuits. And so we had qualitative issues here that involved aspects, dogmatic issues, legal issues, how to understand the legal framework in Brazil when it came to the implementation of the right to health, and also the respect to the right of health. There were many discussions, the lack of resources, the separation of the branches, the criteria for the judicialization, and so the minimum principle started being used, the proportionality, and this is a doctrine debate, or a debate about doctrines. And I would say that we're going to discuss the second point due to my only 15 minutes. And so the judicialization of the health in Brazil, and it's also called the judicialization of the policies and the the political aspects, and now we have the COVID-19 pandemic. Not only because of the updating of this topic, but many issues that were highlighted. And these aspects made everything even more even things even clearer because of the pandemic. Of course, this is not a specific panel about the right to health, but all of the issues they discuss about this issue, the right to health. And so we have the Supreme Court is appointing now 8.5 million lawsuits at the Supreme Court regarding COVID-19. We have 10,000 500 rulings approximately, and over 5,000 lawsuits considered highly complex. There is nothing similar. Please, the Professor Danielle, correct me if I'm wrong. At least I don't know about this. I don't have access to this. The main constitutional courts, okay, there are lawsuits regarding the pandemic, but there's nothing similar, not even in the Latin American scenario, in the world scenario. And we can say that to a certain extent, the novel coronavirus and the pandemic, they increased the judicialization process in Brazil. And I would like to emphasize, I'm going to discuss the third point of my presentation. Some aspects, they catch my eye. First of all, it became more visible the direct relationship between the right to health and other human rights and fundamental rights, and this is important. This was never made so visible in so many lawsuits, and so the promotion to and so there is a limitation of the lawsuits, other fundamental rights, okay, that we have to discuss. The right to meet one another, the right to go and come, to move around. And we also have the fake news, the protection of personal data, the right to public information, the access to information, and other essential rights that and so other essential rights, yeah, freedom of movement. And we have to promote the right to health, the access to information, transparency, the federative pact that we have. And so I could mention many others, but due to the time we have, I have to stop here. And of course, we also have problems that we are facing. There is a scope of issues that are being taken to the Supreme Court only in these months that have passed in this year. They go beyond the conventional, and we have the federative issues that always go to the Supreme Court, but it was an open door for this judicialization process at the end of March of 2020. And so it was the mandate of the states and municipalities to work to fight against the pandemic, okay, jointly with the federal government. And we also have legislative processes, provisional measures, provisional ordinances, and many issues were discussed at the Supreme Court, yeah? And so the equipment, the responsibility of the doctors, vaccination, and what I would like to emphasize, and so I could only select a few cases. And so let's go to some final remarks. I would like to discuss this topic way more, but it's not going to be possible due to our time constraint. And so the practices, or the bad practices, contrasting the best practices with the bad practices, let's focus on those that potentially, at least from my understanding, they can be understood as movements, positive movements, to fight against this judicialization. 5 advances that can be emphasized, even though they can become better. Without okay, without ignoring the resolutions created by the CNJ, cooperation, rationalization, monitoring, efficiency, analysis of the effectiveness, social participation, the civil society's participation, the councils. From a judiciary perspective here, some aspects that have been part of the agenda, and Danielle, please correct me if I'm mistaken, okay? And so we need to reinforce, visibly reinforce within the pandemic. We need to have an objective perspective of the right to health. And we have to consider individual situations. But there is a trend to prioritize the number of cases collectively and the right to health that the collectivity has. And we also have to separate and to divide the mandate, so the federal government can do the general management and with the assistance of the state and the municipalities. And there should be the possibility for us to balance the issues based on the different differences between the states, the municipalities, and we need to have cooperation, solidarity among the entities of the federation. This seems to be very beautiful, but in practical terms, they don't follow this logic, but this logic is based on the Supreme Court and on the Supreme Court's rulings, and we know this. And a third aspect that I would like to emphasize, not only during the pandemic, but we have to follow scientific data, scientific evidence, and scientific suggestions when it comes to the management and the handling. And so some rulings and sentences they advance by using the scientific data and knowledge that we have, and this is a polemic criterion, okay, to solve conflicts between these fundamental rights. And the fourth aspect, I'm almost wrapping up, is the gradual increase not only of direct actions to overcome the pandemic, but the actions that we call structuring actions. What do I mean by that? Besides dealing with the issue in a more systemic way and in a more comprehensive way, we also allow a possibility of having an additional dialogue and also a monitoring, a following up, a gradual monitoring, earmarking the budget for this, and we can verify this in many sentences, and involve the vaccines and the protection of vulnerable groups, the indigenous populations, the maroon populations, the inmates in our prisons. And these are only a few examples, okay, that have come to me now, but of course there are others. And also there is a trend of the Supreme Court, and we should greet them for this, and also the strengthening of the protection of the Supreme Court as an agent that is going to protect the vulnerable groups in Brazil. And it seems to me that this was emphasized in this context of the judicialization of the health that we have in Brazil during the pandemic. And wrapping up, I would like to say that in terms of best practices, we have made significant advances. And so the laboratory is very rich in terms of academic discussions, judicial practices, legal practices, normative practices, governance practices. And I believe that an event such as this, discussing these topics, is going to promote and foster reflections, discussions about this. And I'm very glad for being a part of this moment and this event. Thank you. Thank you so much, Dr. Ingo Sarlet. You were punctual. You respected your 15 minutes. Oh, you didn't even go over 30 seconds. So thank you so much for your brilliant presentation. And even though it was very fast, the topic was very important for us. And now, As a counselor of the CNJ, I am following the Healthcare Council, and we are working towards this end that was mentioned by you, Professor. What was verified by the CNJ is that truly between the 1990s and the year 2000, if you filed a lawsuit, you got it. And so to avoid any loss of life. And after, so between the year 2000 and 2010, if you filed a lawsuit, you got it. Not before that. Sorry, I made a mistake, yeah? And so we are doing this work, and now we're going to implement a project to carry out a structuring action or activity. Thank you so much. I would like to pass the floor. I always read your books, and it was wonderful to read your books, and it was wonderful to get to know you personally on this panel. So now I'm going to pass the floor to Dr. Daniel Wang. He is a professor. He teaches law at the Getúlio Vargas Foundation. He has a master's degree from the University of São Paulo. He has a philosophy degree from the London School of Sciences. And he has a degree also from the London School of Political Science. He was a professor at the London University between 2015 and 2019. He was member of the Ethics Committee in England, and currently he is part of the Bioethics Committee at the Sírio-Libanês Hospital in the state of São Paulo. I would like to pass the floor to our panelists.
It's a pleasure to be here. Thank you to Dr. Walter for having remembered me. And I'd like to do a homage to Professor Ingo Saleh, which I found a master, not only of my generation, but others. And so it's a great honor. And I saw that my speech will close the scientific, and they say that the first impression is the one that stays. And you, if you've had a boyfriend or girlfriend, maybe you know that the last impression might be the one that lasts. But being here in the company of Professor Ingo Saleh, Professor Candice, that despite any wrongdoing on my part, that will be a good level panel. I'd like to take the opportunity in terms of the jurisprudence of as regards the response of the Brazilian state in COVID, focused in four themes: social distancing, ICU. I wanted to deal with these themes, and because these are themes that are absolutely relevant, the response of Brazil, but also because in these themes we can observe a certain posture of the Supreme as regards these themes. And Professor already advanced some of these, but some of our Supreme Courts as regards these. And before going into each theme, the fact that so many issues from the COVID comes to the judiciary is no surprise. These important themes rarely don't arrive at the judiciary because there are great losses in the economy, and the responses end up interfering in rights and interests. So it's natural that this generates conflict, insatisfaction, and all of these can result in judicial demands. But currently there are some characteristics in Brazil that increase this judicialization. First is the federative conflict that permeated the response of the Brazilian state since March 2020, conflict between federal government and states, and this conflict ends up demanding a solution. And I think another characteristic, I don't want to politicize my speech too much, but the idea that the federal government has not been based on science a lot. This creates insatisfaction, and also judicial demands come from this. So in terms of discussing the 4 themes I want, apologies, I'm going to use the PowerPoint and might improve. So we could start here in restrictive measures to prevent contagion. Like I mentioned right at the beginning, some states sought to adopt measures of restriction, of movement, of joining, but this was faced immediately by the federal government, which had a different view of how the pandemic should be faced. So in March 2020, they give the strong to the federal government what would be the essential services, even if at the local level there would be restrictive measures. And this would have the power of limiting the capability of municipal and state powers of doing social distancing measures. They would be limited in which intensity these measures of social distancing would be imposed. The Supreme Court, though, however, that in the 6341 determined that local municipalities and the state to manage their policies of combating the pandemic. And you're going to say that the response to the, and they will talk specifically about the WHO recommendations and the ADPF 672, where you ask the president in terms of social isolation, taking at the municipal and state level, that the president will abstain from the practicing acts against those policies of isolation. And the 672, it guarantees to municipalities and states to take their measures that they find necessary to control the pandemic. But the judiciary, the Supreme Court in this case, doesn't determine that the federal government should take certain measures. The Supreme Court cannot determine what the federal, they just gave it to the states and municipalities the ability to take their own decisions. And here we have the first draft, let's say, a certain hesitation from the Supreme Court of adopting very complex measures. And what do I mean by that? Those that need a very ample specific knowledge, measures whose implementation would be complex, and measures whose consequences would be harder to forecast, maybe polycentric in nature. So here we see once more recognition of the power of states and municipalities and a hesitation of taking on very complex. And this, what Dr. Salles talks about, structure measures. So in the ADPF 811, the Supreme Court kept by majority the closing of religious temples in São Paulo. It's not only the competences of the state, but this was based in scientific or technical data. So here we can notice some things in guaranteeing that the states and municipalities can take their decisions, and a focus in science and a certain hesitation in imposing complex measures. So the ADPF 671, we know there's a big difference between private and public health. Just to have an idea, the beginning of the pandemic, it was 50% from the private health system and 50% in the public. But that was the situation right at the beginning. But the private system takes care of 25%. So you had half for 75% population, 50% for 25%. So the ADPF that was proposed by one of the political parties, that the federal government requests these ICU beds and create a single queue, let's say, and they would be part. The Supreme Court denies that because it understands it's in the discretionary power of the executive, and so it's not the role of the Supreme Court to do so, and ignoring local conditions. And also this would take from the state governments the power of managing the ICU beds and hospital beds, so avoiding very complexes and guaranteeing states their power. And when I say hesitate, I'm not doing a criticism. I think there's very good reasons to hesitate in certain circumstances in taking very complex measures. The ADJ 6362, it goes on the opposite, to limit the power of states and municipalities to request private goods. That every request done by state and municipal powers would need to have authorization from the Ministry of Health of any kind of requisitioning that they do. And the Supreme Court denies because it would harm the federative separations, would increase the discretionarity of state and municipal, but to say it's unviable. But this would demand a structure that might not be possible. Once more, the Supreme Court guaranteeing state and municipal power and hesitating to take complex measures like creating a single few, or that the Ministry of Health create a system to authorize requisitioning their various actions in which the states, that the union, that the federal government cannot request goods that they bought and from private, and this gives greater autonomy and conditions for local policies, because it would be very frustrating if the federal government could take up from them materials or equipment that they got to deal with the pandemic. So this would demand a more complex structure, and also trying to protect municipal and state autonomy. Here things start to become very interesting. In March 2021, various states, we have 3 here, but way more, they would ask that the federal government still keep paying some of the ICU beds, but in the beginning of the year, the federal government stopped this financing. They went into the justice and they understood that the recognition that the federal government has to give this logistic and financial aid to these ICU beds. And the ADPF 756 deals with the tragedy of Manaus that then spread over Brazil, and the ADPF 756 asked for the supplying of oxygen, campaign hospitals locked down with the help of the national force, and asking for more doctors to Manaus. The Supreme Court works partially, and they only obliged the government to send oxygen. Once more, this seems to be a case of the Supreme Court hesitating in taking complex decisions. They have no problem in obligating very specific, send money, send oxygen, but complex actions, the Supreme Court is hesitant. So one thing is to send oxygen. It's another to order them to make campaign hospital, which professionals, which materials. Would it be better to buy private ICU beds? or maybe declare a lockdown in a city. So a logistic that would demand the transfer of professionals or changing of regulation of the medical profession in Brazil. So the Supreme Court once more sought to guarantee the material conditions for the response and hesitates to take measures that are very complex, but it compensates this hesitation with something which the literature, which is a demand to demand from the federal government a plan to deal. So it's not the judiciary saying you should do A, B, and C, but they demand a plan, demanding transparency, if some kind of basis of what is going to be done, and controlling a little bit closer of what the public entities are doing. So do a dialogical action in terms of dealing with the hesitation, and instead of demanding more complex. Once more, hesitancy is not a criticism. I think there are good reasons for being hesitant. And now to the last theme, which is the vaccination. Sorry, I'm worried about going too fast. The APDF 754, it comes from a tweet. President Bolsonaro, when he says he wasn't going to buy the Chinese vaccine of Governor Doria. And this leads to this ADPF that requests the federal government to present their vaccination plan, commitment to buy the Chinese vaccine, and the buying of registered vaccines. What does he do? That they deliver the plan to purchase vaccines, and that these be based on economic and technical criteria. Funny that he put the economic. So it doesn't go so far as to oblige the federal government to take a commitment of buying Coronavac or other vaccines, but they says that the government should have plans and it should be based on scientific criteria. Once more, the Supreme Court avoids imposing complex and putting a dialogue, and this created an umbrella for various other types of requests by the Supreme Court as regards the vaccination policy, timetable, the number of injections available, as regards the priorities for vaccination. The Supreme doesn't say you have to put this group in front or not. It says, what I want is a list, clear criteria, who's going to do, who's going to get that before and or after, in a dialogic, let's way, once more to compensate the hesitancy. So ADPF 770 and the 86586, they are also guaranteeing that states and municipalities have some kind of autonomy for their own policies. And the 770 and the 6586 guarantees that the states can have their own vaccination policies, which is a novelty, because vaccination had always been centralized in the federal government, and it was decentralized for the COVID, and the Supreme Court once more says that any policy decisions in terms of imposing vaccine, they have to be informed by scientific data. Once more, we have this standard to protect state and municipal government, emphasizing science and a central role, and hesitancy in those complex decisions. And like Professor Ingolstadt had said about these dialogic actions. As regards, for example, the Maroons, the Quilombolas, there is a lot of subjects as regards the advantages and disadvantages. So, to conclude, a presentation way more limited than Professor Ingo's, but there are some themes, some conclusions that we can take from these four themes. First, that the Supreme Court acted in order to preserve the actions or the freedom of action of states and municipalities. They gave centrality to scientific information in those decisions. These were in those cases, but you have the same idea and responsibility of public agents, and that serious mistakes could result in responsibility, especially if it doesn't have scientific basis or follow the WHO, because what we call the soft law comes from a jurisprudence, and now we have this hardcore, so that the Supreme can evaluate the actions of individual or public policies. So the Supreme Court, when they demand a positive action, it doesn't have problem in asking for specific and execute things to be done in execution, but when they're more complex issues or structuring issues, they prefer this action in terms of dialogical transparency and explanations. And finally, interesting aspect, the Supreme Court acted in a very cohesive way. There is a disseminated that we don't have a Supreme Court, but 11 justices or ministers. And in combating the pandemic, the Supreme Court was very cohesive and monocratically and frequently confirming what. And yes, there is a change when the Minister Cássio Nunes comes in, but we can say that in general they acted very cohesively. With that, I close my speech. Thank you once more for the opportunity and your patience. Thank you.
Thank you, Dr. Daniel. It was with great satisfaction and joy that we watched these two panelists tonight, because even though it was a short period of time, you brought to us deep, important information, and you were very pedagogical. You were very like a professor, I mean. And so I am not going to make any kind of comment, because the two panelists, you guys have much more knowledge than I do. But on behalf of the CNJ and on behalf of Justice Fuchs, I believe that my friend is here waiting to wrap up the event, if I'm not mistaken. I would like to thank you for your participation, to thank both of you for your participation. It's a great honor to take part in this as with Professor Ingo Sarlet and Dr. Daniel Wang. So thank you so much, and I congratulate you on the brilliant presentations. Even though you respected the 15 minutes, you were perfect and brilliant. So I would like to pass the floor to the Master of Ceremony once again. Thank you so much for the presentations. And to wrap up the first legal colloquium, okay, the best practices of the Brazilian law, we would like to invite Dr. Walter Schechner de Araújo, the General Secretary of the CNJ, and Dr. Jean-Michel Arrigui, the Secretary of Legal Matters of the OAS. So thank you very much. These 2 days have been extremely intense, and this was an idea that we had quite some time ago, and I asked Professor Araújo, Walter Araújo, let's do joint work together to discuss the topics between the CNJ and the OAS, and let's use the same models of other countries. How can we get to know each other, exchange the best practices, information, and between judges, professors, lawyers, prosecutors, when it comes to some topics? How can we work together based on this legal framework. And so I connect this to the international legal framework because it's impossible for us to separate what is national from what is international. Yes? And so we at the OAS, we try to create, to develop, and disseminate the law, international law for everybody. And so the main idea, and I always thought that we were going to have a small meeting with government officers and officials. And Dr. Araújo is going to organize this seminar in which we have all the authorities here, all of the judicial, the academic authorities from Brazil, and we are discussing in amazing, amazing topics. So what would I would like to do is to thank all of you. I would like to thank the CNJ. I would like to thank the Supreme Court, all of the associate justices, the members of the academia, all of the participants of this wonderful colloquium. But for me, it seems that the most important is that this journey has shown me two things. First of all, that there is a wide space, a lot of space for us to get to know more and more, to exchange the best practices, to exchange information and experiences with Brazil. And above all, what we have in Brazil could become a role model, an example, a model for similar issues and countries. And we can exchange experiences between countries, among countries. And the challenge that I would like to leave to Professor Walter Araújo for the future. And so, in the next few days, we should have a meeting that we can exchange the best practices possible between the many, many judiciary branches and legal sectors because we have similar problems. We have similar problems. The problems that we have currently are the same that we have all over the Americas, in other continents, in North America, in South America, from Canada until Chile and Argentina. And so we should cooperate, work together, exchange experiences, and to get to know one another better. So many times I have visited Brazil, and what caught my eye in the continent that Brazil is. Brazil is huge, and so I visited Rio de Janeiro, I visited São Paulo, and so in Brasilia, I can buy books that I wouldn't be able to find in São Paulo. Uh, by Brazilian authors, okay? I'm not talking about foreign authors. And so the aspects, the knowledge, Brazil is so different and diverse. And so the people from Uruguay, the Argentinians, the Americans, the legal production and juridical production that Brazil has, we must learn from one another. This is a challenge. And so this is the first meeting for us, and it was wonderful, wonderful regarding the exchanges, the experience. And I'm convinced that all of you, you understand the need that we have, that this should continue. This should continue. And I believe that this is the first step to have a great meeting between legal experts in Brazil and experts from other regions. And in the second phase, we can meet one another and other experts. So thank you so much. Thank you to the secretary of the OAS took part in this first meeting, and he is a lawyer, and he's very enthusiastic about everything that he heard. So once again, I thank you very, very much to all of you, and I thank the CNJ. Thank you so much for this event. Now I would like to pass the floor to Dr. Walter Schenkner de Araújo. Thank you. Good evening to all of you, ladies and gentlemen. I would like to make a special thanks to the Secretary of Legal Matters at the OAS. Thank you, Mr. Jean-Michel Arrigui, for all of your support, all of your partnership. And I'm sure in my mind that this first legal colloquium is going to be the first of many. Many will come, and I'm sure, and they are gonna have different shapes, different forms. And I was thinking about this proposal to unite countries from the OAS and regarding topics so that we can carry out a debate that we had throughout these 2 days, a thematic debate with varied topics. And I accept your challenge. And I'm not going to take long to contact you once again so that we can move forward. I would like to greet Councillor Candice Jobim. Candice Jobim for being the chairwoman of the panel, the chairwoman of the panel. She has been doing wonderful work as the head of the healthcare committee and commission. She has made a wonderful debate, carried out wonderful debates, and we could see clearly, based on the last panel, what we have been doing, the work that the CNJ has been doing. It's a new approach. And so we left the scenario of the 1990s, and then we started the year 2000, and then no lawsuit was won, and then all of the lawsuits were won. So access to medication, access to a bed in a hospital, and as a rule it is preceded by an analysis, a technical analysis of the topic, the object of the lawsuit. So should we follow the judicialization process or pathway? And so the CNJ has been allowing, and I believe that the committee that you preside is important for that, so that we can move forward and advance in terms of the detailing. What is law? What is a right? What is the legislation? And what should the government do? And so Professor Ingo Sarlet and also Professor Danielle Wang also mentioned we are all unconditional fans of Professor Ingo Sarlet. I don't know if Professor Ingo is going to remember. The first time we met was in Heidelberg in Germany. And so he was there having a conversation with Professor Brugger. And so he's a benchmark and a pride and joy for Brazil. A Brazilian professor that is acknowledged and well known in Europe. And this is not easy to achieve. So here I would like to thank Professor Ingo Sarlet, Professor Danielle. Okay? He looks like a teenager, he looks like a young man, but he has vast knowledge, deep knowledge. I don't know if I mentioned with you, Daniel, but I heard your name for the first time many years ago via Professor Carlos de Souza. He said, pay attention on this young man, pay attention on this young man, because he's going far, he's going places. And I have always tried to get closer to you, to follow your work because of the high quality of the work that you do. And so I would like to thank. And I would like to say that we had 2 intense days, events with debates, with panels, with presentations, and the panels were so unique and so different. It was like scenes, different scenes passing in front of us, and I was reminded how much our country has to offer in legal matters, in legal topics, in many sectors. We had a panel about the rights of consumers. We had a panel about 4.0 or 4.0 justice. And the judiciary branch has investing a lot in technological innovations. And I have already visited many countries in Europe when it comes to electronic issues. It's difficult for you to find a country that has so much adherence to technology such as Brazil. And this is our profile, our characteristics, and maybe this could become best practices in the international scenario. Today we discussed the Maria da Penha law. Brazil, before the Maria da Penha law, only saw domestic violence as an infraction. With that old idea that between a husband and wife nobody should interfere, and so
Metal.
now we have a different scenario. We have lawsuits to avoid the partner, the male partner, from getting close to the lady. And so we are trying to avoid domestic violence. And we had a panel about agribusiness. And so the interesting thing about this panel was the relationship between agribusiness and the environment. And one of the most interesting panels and one of the most important panels at the moment, because of our reality, is the panel on the judicialization of our health. And so this country was very good, and the exchange of ideas and experience is going to facilitate the expansion of successful initiatives. Uh, Between Brazil and the members of the OAS, okay, and also to all of the American states. And Ahigi, I was curious to analyze the charter that created the OAS and many things that are mentioned as the principles and the guidelines to be followed. So all of them, they were related to pacification, social peace, and so the uniformity of the organizations of the institutes, adjusting things to the local realities. And so it can bring with it advances and progress to all of the countries that are members of the OAS. And finally, I would like to thank all of the panelists, all of the speakers, all of the chairmen and chairwomen, and all of those involved in the organization of this event. Carla from the protocol department, those from the communication department. We carried out worked with the translation of the videos, with the subtitling, with simultaneous interpretation. Our master of ceremony tirelessly doing his work. So thank you to all, and mainly to Professor Ahigi. And there is no doubt in my mind that for sure we're gonna have a journey together that is gonna be beautiful, similar projects to this one, other events, and we're gonna consolidate this important partnership between Brazil and the OAS, and also among the other member states of the OAS. And so to wrap up, I would like to pass the floor to the Master of Ceremonies. Ladies and gentlemen, with a due authorization, we would like to declare the first legal colloquium between Brazil and the OAS concluded, okay? The best practices in the Brazilian law. I wish you all a good night. Thank you.